Special Matter Number Case Number GP 10 of 2019, the SIU Ref 4878/19-249. The matter of Special Investigating Unit and 2 others versus Khosi Sikutabatu, Gustav Dikabe and 2 others.
As the court pleases, my lord, yes. Mr. Fisher and I appear for all 3 applicants in this matter, the Special Investigation Unit, the Minister of Police and the Minister of Justice and Correctional Service.
Thank you.
As the court please.
Thank you.
May it please the court, my lord, I am for the first respondent in the matter, instructed by several attorneys to my right.
My lord, just for record purposes, the Government Employees Pension Fund as well as the Government Pensions Administration Agency did not enter an appearance to defend. They didn't file any papers. My instructing attorney, who's the State Attorney Pretoria, never received any correspondence from them. So I assume that they will simply abide by the order of the court.
But Mr. Hubert, just there, isn't it that the normal procedure to follow for the parties who have been served with the papers in an instance where they don't intend recusing and as you have submitted intend actually abiding, that they should nevertheless file a notice to that effect?
I would have expected it, my lord, but it appears that they simply didn't respond at all. So just for record purposes, the only parties before the court is the first to the 3rd applicants and the first respondent.
Yes. So what should the court make of that? Your submission?
My submission is the court can accept safely that they will abide by the decision of this court and follow the order this court will issue, if any order at all. Yes.
And have you got a return of service?
I have a return of service. My lord, my instructing attorney has quickly stepped out, but if I can just in the meantime look for it, and I will hand it up, my lord.
Maybe I should ask Mr. Brown. Mr. Brown, are you aware of the return of service of the application on behalf of the first and second respondent?
Well,
on the second and the third. Yeah.
No, I'm not aware of the return of service, my lord, but the learned friend says that they have been served and the return of service.
You accept.
You accept.
Yes.
Well, look, Mr. Hubert, instead of you people now going through the papers like that because you don't seem to know exactly where it is to be found in the absence of the attorney, before the finalization of the application, maybe if you could hand it.
Yes, I will hand it up as soon as I'm placed in possession of it. My lord, I'm ready to proceed. However, just before the court walked in and commenced, I was approached by Mr. Brown, who tells me he received instructions to make the request to this court. But I'm ready to proceed with my argument. So he asked for indulgence so that I can just mention it to the court for you. Thank you.
Yes, Mr. Brown. I think in chambers you mentioned the fact that you want to take instructions.
That is correct.
And I afforded some opportunity to you in that regard. Have you finalized the instructions?
My instruction, no, unfortunately not, my lord, but I was then given a further instruction with regard to an application which I have to make. I've shown my learned friend the SMS which comes directly from a client with regard to how this matter proceeds further. But before I do make the application, I would beg the court's indulgence for me to speak to client. I don't want to put my head into a hornet's nest without getting proper instructions from client in this regard. It just came through as an SMS, a 2-line SMS.
Your client is not here?
No, he's close by. The offices at which he works are close by. So it is quite easy for us to get to speak to him. But the nature of the instruction is such that my learned friend will confirm that it is absolutely imperative that I do speak to client before I do execute the instruction.
Are you at liberty to disclose to the court in what are those instructions?
My Lord, I have no bar placed by client on informing the court what the instruction is, but I think it would be prudent for me to speak to client first before I do proceed with the instruction. I think it's an instruction, given the nature of the matter and the discussions earlier this morning, which perhaps needs a little bit more discussion and guidance from my instructing attorney and possibly from myself. I'm not refusing to advise the court what the instruction is,
yes,
but I think it would be prudent at this point,
yes,
first to get proper instruction.
Well, of course, I think you won't find anything untoward when the court puts that question
No,
to
certainly
you,
not.
because you will be aware of the fact that we were expected to start these proceedings at 10 o'clock.
That is correct.
And for what happened, of which I'm also aware, we were not able to.
Certainly.
And so now it's past actually 12:30.
Yes.
And that is why it is in that context that I'm asking you in that spirit if you are at liberty to disclose.
Yes, my Lord. I prefer to speak to client first, my Lord, before I make the disclosure or even proceed with the instruction, my Lord.
Yes.
I don't want to muddy the waters before we actually deal with the substance of the instruction.
Yes. How long do you suppose then you will take the instructions?
My Lord, I think 30 minutes would be sufficient for us to
But that will take us to lunch hour.
Yes, my Lord. I also don't want to rush it. It is quite serious, my Lord, and I don't want to rush it. I want to apply my mind properly, and I want to guide the client properly before we continue.
Thank you, Mr. Brown. Anything else?
No, that is all.
Thank you. Mr. Yu,
Well, I have nothing to add.
your friend.
I will deal with whatever application my learned friend intends to launch. We need to launch it, or if it is launched.
No, I have nothing further, my Lord.
In the circumstances, this matter will then stand down, and in order to accord Mr. Brown on behalf of the first responder to take instructions, and we will only resume these proceedings at 2 o'clock. Apologies.
All right.
Hij is voor. Precies wat het is.